greetings also on my behalf. And thank you for inviting me to participate in this conference. After listening to all of today's presentations, I realized it's really hard to be the last one because our regulations are in parts very similar, and all of you already have said a lot about it. So I hope I will say something new. My presentation today will be more narrow as some of others that we heard today. I will briefly present the relevant regulations, so Slovenian regulations that apply to the recognition of documents in civil proceedings. And I will focus primarily on the probative value of foreign documents in Slovenia, and will not focus on formal and substantive effectiveness of the actions. I wrote more about that in the paper, so I will try to finish this conference on a bit lighter tone. In the area of recognition of foreign documents in civil proceedings, of course, we have to mention some legal acts, but maybe before we go into those, as some of you already mentioned this topic, the question is how to decide or how to determine whether the document is foreign or is not. The origin of the document is determined in Slovenia according to the law of origin of the document, so lex loci emissionis, while other circumstances are irrelevant. Let's say language of the document or nationality of the persons to whom it relates. The origin of the document is, of course, important for us for the choice of law under which it is assessed, and also for determining its probative value. So if we look maybe just quickly, firstly, of course, Slovenia is bound by the Hague Apostille Convention because it is the successor to Yugoslavia, which became a party to the Hague Convention, and then Slovenia later on declared itself to be bound half of the year or 1 year after Slovenia became independent. So this convention has been binding on Slovenia practically since the beginning of its independence. Then, apart from this Hague Convention, we have to mention, of course, also in Slovenia bilateral agreements. Most of the bilateral agreements on legal aid in civil matters that are currently binding on Slovenia were concluded by its predecessor, so Yugoslavia. After the breakup of Yugoslavia, Slovenia itself concluded agreements in this field primarily only with the countries of the former Yugoslavia, so with Croatia, Bosnia, and so on. So here we have all the bilateral agreements that are binding to Slovenia. We have 9 bilateral agreements in the first column with states outside EU, and then of these 9, we have the first 3, so with the Bosnia and Herzegovina, with Republic of North Macedonia and Serbia, that Slovenia concluded itself, and the rest were concluded with Yugoslavia. And then in the second column, we can see the 13 bilateral agreements with EU member states in the field of legal aid in civil matters. And also the great majority of these were concluded when Slovenia was still part of Yugoslavia. And now, then later on, Slovenia has notified its accession to all these agreements, except for the agreement with Croatia, also a former part of Yugoslavia, that Slovenia concluded as an independent state after the breakup of Yugoslavia. So, of course, here with these EU member states, as you all know, it should be noted that bilateral agreements concluded with these member states may apply only if there is no EU legal act in force. for a particular area or legal institution that specifically defines the relationship with bilateral agreements. And before using a foreign document, of course, it is necessary to determine whether Slovenia has concluded a bilateral agreement with the country of origin of the public document. And in addition, it is necessary to determine whether the country of origin of the document is also a contracting state to the Hague Apostolic Convention. And as we already heard today, if both are affirmative, then Article 8 of the Convention must be taken into account. And the legal source that establishes the less stringent formal requirements must be applied, either the bilateral agreement or the Hague Convention. In the event one does not apply and the other applies, of course, then the one that applies, the one that is binding applies. And in the event of both negative responses, so when relevant two countries do not have a bilateral agreement and when the other country is not contracting state to the Hague Apostolic Convention, then the Slovenian Act regulating the authentication of documents in international legal transactions apply. With a slight difference to the what my colleagues said earlier. So this is quite a new act from 2017. However, it is quite similar to the ones that we had in the time of Yugoslavia. Without adequate authentication, a foreign public document lacks the probative value of a public document before Slovenian courts, and then in such a case, it can still be considered a private document. However, as a private document, this foreign public document does not have a special probative value, as it is determined in the Slovenian Civil Proceedings Acts. We will talk about this a bit more in a couple of minutes. Here, I would just like also to emphasize once more that the authentication according to the relevant act, either to the Hague Convention or to the bilateral agreement or to the Slovenian Act, does not confirm the authenticity of the content of the document. Just to say a few more words about bilateral agreements binding on Slovenia, all of them fully abolish the legalization of documents in civil cases, and none of them provide for the replacement of legalization with a national authentication process. Some of these provide an exemption from authentication only for court documents. Others also include notarial documents or documents issued by competent authorities, while the most liberal ones also include private documents authorized by a competent authority. Here, our colleague from Serbia earlier addressed a question to Professor Hoško from Croatia, but we all have the same bilateral agreement with Bulgaria here, also Slovenia, as Serbia and Croatia. So if I can give my opinion here to answer the question, I would say that the regulation in the bilateral agreement with Bulgaria can also apply by analogy for notary instruments. And maybe I will be glad to hear also the answer of Professor Hoško later in the discussion. However, it should be noted that even the existence of an agreement providing for the exemption from authentication of documents does not necessarily mean that the competent authority in the other country will not require the party to provide an authenticated foreign document. The reason for this may lie either in the domestic legislation of the foreign country. Let's say that the domestic legislation of the foreign country requires the authentication of domestic documents also, and consequently also of foreign documents. Or the reason can be in different interpretations of the provisions of international agreements. And I can say that according to the practice of the Slovenian Ministry of Justice, which certifies domestic documents for use abroad, it appears that some countries, despite the existence of a relevant international agreements, so bilateral agreements or something, that in some countries the authorities did require parties to bring Slovenian documents which was certified. So we can see that even if we do have these bilateral agreements without any requirements for authentications, in practice may be situation different. So maybe this is enough on bilateral agreements, and I would just like to say a few words on presentation on provisions of Slovenian Act regulating the authentication of documents that I mentioned earlier. This act is the legal basis for authentication of documents, so foreign documents to be used in Slovenia and also Slovenian documents to be used abroad. Additionally, we have two other rules that need to be applied. Technical issues and forms of authentication of documents for use in the Republic of Slovenia and abroad are regulated in these rules on the authentication of documents in international legal transactions. And additionally, the rules on the certificate of authentication must also be applied. And this one specifies the content on the certificate of authentication on a document intended to be for use to be used in Slovenia, and unless otherwise provided by an international treaty or a legal act of the EU, public documents issued in a foreign state which are intended to be used in Slovenia shall be then authenticated under this act. However, I would like to emphasize the rules do not cover private documents, which are therefore not recognized according to this act. And then the probative value of private documents is determined on a case-by-case basis in accordance with the rules on the free evaluation of evidence that we already heard about it today. So we also have the same rule in Slovenia, meaning it is up to the judge in a specific court procedure to decide whether to recognize the validity of a foreign document or not. So how to get this probative value of a foreign public document? When using Slovenian Act, foreign documents firstly have to be authenticated in the state of origin. And then after this, they are authenticated by the ministry responsible for foreign affairs or by a diplomatic or consular representation of the Republic of Slovenia abroad. And if the authority to which a foreign document is submitted has any doubts about its authenticity, it may request from the ministry responsible for foreign affairs to verify whether it was issued by the authority indicated therein or not. So an official at the Ministry of Foreign Affairs or consular and diplomatic representation shall authenticate these foreign public documents on the basis of deposited signatures. Here, just to give you an impression, I wrote down all the persons whose deposited signatures can be basis for authentication by the Slovenian Ministry of Foreign Affairs or by diplomatic or consular representation. Of course, we will not go through these right now, just to get an impression what can be the basis. So this is the procedure for certifying and using foreign documents in Slovenia. And what is important here is that when a foreign public document is authenticated according to those rules, it becomes equal to the national, so Slovenian public document from the perspective of probative value in civil court proceedings. the rule the rule for that is determined in the Civil Procedural Act, and we can see it here. And it says, unless otherwise provided by an international agreement, foreign public documents certified in accordance with the regulations shall, under the condition of reciprocity, have the same relevance as evidence as national public documents. So here it is important to emphasize that public documents as evidence have special weight in Slovenian civil proceedings. With regard to public documents, namely the special rule of evidence applies. And it says that public documents, here, if just a minute, that the documents that are public documents shall be the proof of the truth of what it certifies or regulates. So if the document is a public document, it is deemed to be true what is stated in it. And this is quite important. This is the only rule regarding the evidence in Slovenian civil procedure. And it is quite important that foreign public documents get this special value when authenticated according to the relevant rules. However, of course, the party may assert and prove that facts contained in a public document are false, or that the document has been incorrectly composed. However, this is quite an important effect of authentication in civil procedural rules. Maybe just to mention also the situation on the other side. So what is the procedure of Slovenian public documents when they are to be used abroad? So the rules on the authentication of public documents issued in the Republic of Slovenia that are intended to be used in a third country are also determined in the same act that I already mentioned earlier. However, again, we need to have in mind that such authentication does not confirm the authenticity of the content of the document. Then the authenticity of the signature of the person who signed the Slovenian document shall usually be established on the basis of the deposited signatures. There are some other options. However, this is the most usual one. And also it's the same with the authenticity of a seal or stamp on a document, which shall be established on the basis of deposited seal or stamp impression by authority. Then the confirmation of the authenticity of the signature of the person who signed the document, so the Slovenian document, and also the authenticity of the seal shall be carried out by all district courts in Slovenia, specifically by district judges. So on the first stage, we have district judges who confirm the authenticity of a Slovenian public document. Then, before this document goes abroad, we need two more stages. The second stage is a confirmation by the ministry responsible for justice, which of course authenticates the signature of the judge. And then on the third stage, we have authenticity that is made by ministry responsible for foreign affairs and who certifies or authenticate the signatures and stamps of the ministry responsible for justice. So we have three stages of authentication here. And of course, maybe it's really important to mention that notwithstanding this rule, domestic documents issued by the state authorities may be authenticated directly by the ministry responsible for foreign affairs without prior authentication by the courts and by the ministry responsible for justice. So they get this easier way to authentication, which is of course understandable. For the conclusion, I would just like to say that we can see that the Slovenian Act regulating the authentication of documents in international legal transactions provides for this long certification, which is used where if there is no other relevant international bilateral agreement, and of course if countries are not members of the Hague Apostille Convention. However, given that the fact that there are 27 member states of the European Union, there are 129 countries that are contracting to Hague Apostille Convention, and of course, having in mind that also we have 22 bilateral agreements, we can say that such long certification that I mentioned today is not used in a large number of cases. Thank you for your attention.